California. So before we get started, I'm going to give a quick overview of our agency and what we do. So Disability Rights California, or DRC, we are a statewide nonprofit, and we provide free legal services to people with disabilities. With any disability-related issues, we have attorneys and advocates statewide, and we can help with a variety of issues from access or discrimination issue with housing, with transportation, with education, which includes special ed and higher ed. We can also help with public health benefits such as Medi-Cal, in-home supportive services, or Social Security overpayment issue that relates to work. And within our agency, we also have different programs. Some examples is our Office of Client Rights Advocacy, or OCRA. They specialize in helping clients of the regional center, and our Client Assistant Program, or CAP. They specialize in helping clients of the Department of Rehabilitation. As our hosts have stated, Q&A will be at the end, and everything you see today, the presentation, any links or website that might be shared in the chat will be sent to you afterwards. If you have any questions, you'd like to talk to one of our advocates about your particular situation, you'd like to have a one-on-one appointment, please give our agency a call. Our phone number is in the chat. It is 800-776-5746. And our phone lines are open Mondays, Tuesdays, Thursdays, and Fridays from 9 a.m. to 3 p.m. If you call us outside of those hours, you can leave us a message and our advocates will get back to you as soon as possible. So without further ado, I'm going to quickly introduce our presenter today, Maria Ariate, and she is one of our senior attorney with DRC. Her expertise is in the area of public benefits, and Ms. Ariate has a Bachelor of Science in Business Administration from California State University, Long Beach, and a Juris Doctor degree from Loyola Law School. So without further ado, Maria, please take it away.
Thank you, Raymond. Hi, everyone. Good evening, I would say. So today we are going to talk about the different alternatives to what I call a full conservatorship, meaning someone is going to have, the conservator is going to have the right to make decisions over someone else. And we'll talk a little bit more about that. But the information that you're going to get today is for today. Tomorrow it may change. So just so that you know. And we're not here to give legal advice either. So we have to talk about conservatorships before talking about alternatives. So that's what we're going to do. And then we're going to talk about alternatives to conservatorship, which includes supported decision-making, and other things that we're going to talk about in the areas of healthcare, education, and finances. So let's talk a little bit about conservatorship. Conservatorship is you have to go through a proceeding in court and have a judge issue letters of conservatorship. The person who's appointed to make decisions over someone else is called the conservator. The person who's lost rights is called the conservatee. And there are two types of conservatorship: full conservatorship of the estate. So someone who would manage the conservator would manage the person's assets, or of the person. And when we talk about of the person, is about their health care, where they live, do they go to school, who they hang out with, that kind of thing. And so usually people, when they seek conservatorship, they seek a conservatorship of both areas, right? So the proposed conservatee is presumed to have capacity, and a judge has to find otherwise. When we're talking about conservatorship of the estate, the conservator, because someone filed a petition, has to show that the proposed conservatee is substantially unable to manage his or her own financial resources or resist fraud or undue influence. You can't prove this by isolated events. So you have to show a pattern of this usually. Of the person, you have to show that the person is unable to properly care for him or herself. Uh, for example, meet the needs, physical, food, clothing, shelter. They usually look at activities of daily living, like dressing, toileting, feeding, laundry, etc. So, when parents think about getting a conservatorship over a child, it's not only parents. I mean, anyone can seek a conservatorship over someone else. I can file a petition in court seeking conservatorship of my mom. Whether I win or not is another matter. But when parents usually think about this when their child is about or before turning 18, because what happens when a minor turns 18 and minor becomes an adult, and minor has decision-making authority over all of his or her life, unless there is a document that takes that authority away. And so parents are thinking, well, what am I going to do when my child turns 18 or later? And usually they hear from schools or doctors saying, oh, you need to go get a conservatorship. But that may not be the best thing for the person. We know that people are concerned about, well, how am I going to access health care for my loved one? How am I going to prevent financial abuse? Or how am I going to be able to link my loved one to available services? And so those are, there's a knee-jerk reaction to think about conservatorship. But we have to remember that conservatorship is never needed just because someone has a certain diagnosis or because that person needs help or because it's the way it's always been. And there's also an illusion of protection with conservatorship. Conservatorship doesn't protect against financial scams, sexual abuse, physical abuse, police arrest, and jury convictions. So a conservatorship is pretty much a permanent decision, and to reverse it is very difficult, um, and rarely successful, because to get to a point where a judge says, yes, this person doesn't have capacity, it means that there was evidence to show that. Now, there is something called a temporary conservatorship, so that sometimes happens, and when the person regains capacity, then that the conservatorship can end. But we're talking here about, like a permanent conservatorship. And so the court, there's an investigator that is will be, even after the court issues the letters of conservatorship and says, yes, this person should be conserved, that's not the end of the court's involvement. The court will always be involved in the life of the conservator and conservatee. And there are supposed to be checkups every so often that the court investigator does, even after the conservatorship. I've heard people say, oh, they don't really do it that often, but they're supposed to do it after the conservatorship is issued. It should be done the next year, and after that, every couple of years. Sometimes it happens, sometimes it doesn't. When the conservator dies, for example, there could be there could be other conservators named. So if one of the conservator dies, well, that's not a problem because you have the other conservators. But if there's only one conservator, well, the court will control who becomes the conservator. Sometimes the court does not respect the chain of succession, you know, and sometimes professional conservators can be appointed. Someone, an entity not related at all to the conservatee. And by the way, conservatees continue to have rights. So this is a form that conservatees get, and I'm going to go ahead and share it with you. So this is a form, notice of conservatee rights, that has to be given to the conservatee. And it says that when a person becomes a conservatee, he or she does not necessarily lose the right to take part in important decisions affecting his or her property or way of life. And we go down. The conservatee has the right to ask questions and to express concerns and complaints about the conservatorship and the actions of the conservator. The conservatee can ask the court to review the conservator's management of the conservatorship if disputes can't be worked out between them. Let's see, then we go down. Conservatee, after appointment of a conservator, the conservatee keeps the right to be represented by an attorney, ask to replace the conservator, ask the judge to end a conservatorship, make or change his or her own will, directly receive and control his or her salary, and control an allowance. Now, it also says that unless the court has limited or taken away that right, and you would have to look at the conservatorship papers for that, the conservatee also keeps the right to receive personal mail, to vote, to marry, to receive visits from friends and family, make his or her own medical decisions. So if you think that the conservatee is going to lose all the rights, that may not, even with a conservatorship, that may not be the case. The letters of conservatorship really outline what rights have been taken away, even in a full conservatorship. So it's important to know this. So we are going to go back to the presentation. And here is the form. This is the direct link to that form. Okay. Now, sometimes conservatorships are necessary, like in emergency situations, the person's been incapacitated, can't give consent, didn't identify anyone to make these kinds of decisions. For example, with an advanced healthcare directive, there's no one else available to provide consent through maybe a power of attorney or like advanced healthcare directive. So in that situation, it might even be a temporary conservatorship. And also to help people make critical decisions for people who have never been given supports. I mean, there are times. Plus, when we're talking about alternatives to conservatorship, there has to be some form of capacity on the part of the person who's giving away a right. And I'll talk about that more as we move on. Okay. So why not think about other options first other than a full conservatorship? So conservatorship takes rights away, important rights. The court will become part of your life, the conservatee and the conservator's life forever, perhaps. And conservatorship can change relationships. There are relationship dynamics and there could be tensions because maybe the conservatee is not happy with what the conservator is doing or not doing. And conservatorships can take time and money, cost time and money. What's the goal? The goal here is to keep the person as independent as possible and let the person shape his or her own life. That's called self-determination. I'm going to talk about all these alternatives, but I want you to think of these alternatives that you see here as tools in your tool chest. And you can use, for example, power of attorney for some decision, or you can use a joint bank account for another decision involving finances. You can pick and choose for the situation that you're facing. It doesn't have to be one thing. And by the way, supported decision making is available for all of these things in all the areas, as I'll show you. So when you're looking at alternatives, look into the least restrictive alternatives. And there is also in the documents, and there's a copy, there's a link here to to a court document, there's a confidential, there's a section called confidential supplemental information form, and you have to show the judge that with a conservatorship that you have looked at least restrictive alternatives and that they're not going to work. So nowadays you have to show why these alternatives to conservatorship wouldn't work for this person before a judge will okay a conservatorship. Okay. So choosing the best decision-making strategy, think about what kind of decision needs to be made. Is it regarding finances, education, other things? How much risk is involved? How hard would it be to undo a decision? And has the person made this kind of decision before? The real question is, when you're thinking about, well, what tool should I use to help this person in life? What's the least restrictive support that could work? I'm now going to talk about the first alternative to conservatorship, which is called a limited conservatorship. And this is only available to people with developmental disabilities. They're regional center consumers. Okay. So if I have a mental health disability and my mom files a petition for limited conservatorship, it's going to be kicked out because I don't have the right disability for a limited conservatorship. And a judge can only take away these 7 rights, up to these 7 rights. So if my mom files a petition for limited conservatorship and checks off that she wants to take away all of these rights from me, it'll be up to the judge to decide if he should or she should. It could be that at the end of the day, the judge may decide that the only rights that are going to be taken away from me is to consent to medical treatment, and that's it. But these are the only ones that can be taken away. There are things that cannot be taken away in a limited conservatorship. It's the ability to control the consumer's salary and allowance, to approve harmful medical treatments, to carry out drug treatments, to sterilize the person, to put the person in an institution, to force the person to go undergo electric shock treatment or psychotherapy. You're not going to get that with a limited conservatorship. So what's going to happen after the petition? My mom files the petition for limited conservatorship, and an investigator will be assigned. And by the way, an investigator is assigned for full conservatorship too. And what's that investigator going to do? He's going to interview me and tell me what's going on, tell me about the process. And the investigator is going to determine whether I'm in a position to attend the hearing where the judge is going to decide on the limited conservatorship, whether I oppose the conservatorship, whether I oppose the person, the proposed conservator, and whether do I prefer someone else to be my conservator and why. Actually, Lonnie, we need to change that one. It should say opposes the proposed conservator. Sorry about that. Sometimes I find things that I didn't change. And so the investigator is also going to interview family, is going to figure out whether there's a need for conservatorship. Limited, here we're talking about limited, but like I said, investigators are also assigned to full conservatorship cases, and look into whether the proposed conservator is suitable. Before you guys ask me, I'm going to tell you the answer to the question, especially for parents who have children who are going to be adults pretty soon. They're going to be turning 18 pretty soon, and they want to know, well, how soon should we be filing if you want to do a conservatorship or a limited conservatorship? How soon before age 18 should we be doing it? And I'm going to tell you, frankly, I don't know, because there are a couple of things. First of all, we don't know how long the investigator is going to take to do the investigation, because the investigator will then submit a report to the judge. I've heard this investigator this whole role of the investigator taking months to someone in the audience once said, well, she filed for limited conservatorship for her son. And the investigator took 8 months to do the investigation because the investigator even called family in Mexico. So I don't know how long the investigator is going to take to do the investigation. And secondly, you're going to be filing for a limited conservatorship or conservatorship in your local superior court in the probate division. And you would have to call the probate division and say, how far ahead are you guys scheduling hearings? And that will give you an indication of whether you should be filing those papers, 3 months before your child turns 18, 6 months before. It really depends on each court. Some courts, some probate divisions are busier than other probate divisions. So the factors I have no crystal ball for how long it's going to take the investigator to do the investigation and how backed up or how full the calendar is for the probate division in your superior court. So those are, you could call your superior court, but you don't know how long the investigator is going to take to do the investigation and prepare a report. The regional center is going to be involved. They're going to prepare a report that's going to be given to the court at least 5 days before the hearing. The report is confidential. The parties can get a copy, but it's not available to the public. And that report is going to talk about the type of assistance the person needs, the degree and nature of the disability, the physical, mental, and social well-being of the person, and recommendations about the conservatorship. Now, the court can also appoint an attorney, and that attorney, for example, would meet with me, the proposed conservatee, to discuss the conservatorship, and that attorney will report to the court and to convey my wishes as the proposed conservatee. Now, the other person that can be involved is, I'm a regional center client. We have a sister organization called the Office of Client Rights Advocacy. And for every regional center, we've got a client's rights advocate and an assistance client's rights advocate. I can go to my client's rights advocate from my regional center. They don't work for the regional center. They work to advocate for regional center consumers. And I can say, hey, this is happening. That person can tell me what's going on, talk to me about alternatives, can talk to the attorney that's been assigned for me and the investigator, and may even, issue something for the court. If you don't know who your client's rights advocate is, you could reach out, call this 800 number, and they can tell you, or you can Google client's rights advocacy, and you can go to their website and get that information. So in a limited conservatorship, a judge must determine by clear and convincing evidence that the limited conservatorship is necessary to promote and protect my well-being. So it's a high standard to meet. Done with limited conservatorship. Now let's talk about another tool in your tool chest, which is called supported decision-making. It's an approach that allows the person to make his or her own decisions, and allows the person to go to others to help make these decisions or to help advocate for the person. It mirrors what we do. For example, persons without disabilities, I have things I have to deal with or make decisions about. I can go to family and friend and talk to them, hear them out. They can educate me, give me their opinion, tell me what the risks and the benefits are of what we're talking about. But ultimately, I make the decision. So supported decision making mirrors what typical people do, people without disabilities. And so it's an alternative to conservatorship. And even if I have a conservatorship, I could still use supported decision making, and decide who I want to go to for what. In fact, in California, supported decision making is an alternative in the law through in Assembly Bill 1663. So remember, I told you that there's this form where you have to show the court that you looked at alternatives and that they didn't work. Well, supported decision making is one of those alternatives. So Assembly Bill 1663, like I said, established supported decision making as an alternative to conservatorship. And it also, you have to show why this alternative and others are not going to work. Conservatees are going to get information about their rights. We saw that. And the other thing, this bill did more than what I'm showing you here, but importantly, a conservatorship can be terminated if both the conservatee and the conservator agree. And the bill itself is right there in that link if you want to look at it. So I thought I'd show you this because if you want to learn more about supported decision making, you can go to this publication that was authored by DDS. Another great way to learn about supported decision making, Disability Voices United, and I have information about them at the end in resources. They have really good information on supported decision making. And so, it talks, the first thing is what happens when an individual becomes an adult. For any individual, actually, even if the person doesn't have, developmental disability, they get to make decisions about their lives, just like typical people do, right? So there are many ways, and it says here, if an adult with IDD communicates a need for support in making decisions, how can they be supported? It's with supported decision making and other tools that I'm going to talk about, like healthcare directives, representative pays, etc. So what is the supported decision making? It helps adults with IDD make decisions about their lives. It provides support so individuals can make their own choices. It lets an individual choose another adult or adults, really, could be a group of adults to help them make decisions. This can be a trusted family member, friends, or someone else. Now, I know some of you parents are probably thinking, but that's what I do. That's what I've done with my kids. No, you've made the decision. Here in supported decision making, your adult child is going to be making those decisions. But so what, how can a supporter help a person make decisions? That person can help get information and prepare for meetings with the person, explain what is being said at the meeting, communicate decisions to others, help make choices, make sure that choices are honored, and what are the supporters' responsibilities to support and implement the individual's decisions and choices, respect their values, beliefs, and preferences, act honestly, diligently, and in good faith, provide support only in the areas they want help, the consumer, keep information confidential, not make decisions or sign documents on their behalf. They may do this only when they have another legal document that gives them that authority. How does it work? It's flexible. It could be informal or formal. Informal is an adult with IDD can ask a supporter or supporters, it's not just one person, to attend a meeting with them. This can include an IAP or IPP. It can also include a meeting with a doctor, another healthcare professional. This is just one of the things that a supporter can do. To use it in a supported decision making informally, the consumer says that they want to have a supporter help them at this meeting. They can say this by speaking that, etc. There can also be a more formal supported decision making by way of a written agreement between the consumer and supporters. It must be in plain language and include specific information. and what must be in the agreement. But you don't have to have an agreement. It all depends on what the consumer wants. How could it be terminated? So there's a lot of good information here that you should look at if you're more interested in more information on supported decision making. And like I said, DVU, Disability Voices United, has good information too. So that was the link that we just saw. Okay, so we've talked about limited conservatorship. We've talked about supported decision making. I just want to take a sidestep and talk a little bit about capacity. When we talk about capacity, we're talking about legal capacity, which refers to the person's ability to make decisions and to be responsible for their decisions or acts. Capacity is not an all or nothing thing or solely based on IQ or diagnoses. People may have capacity to make some decisions, but not others. Make decisions sometimes, but not other times. Make decisions if they get help understanding the decision to be made, supported decision making. So we need to talk about capacity with supports. And so instead of thinking or asking, well, what could this person do all alone on a desert island? Maybe the way we should be thinking is, what could this person achieve with help and guidance from friends, family, and professionals, and with technology, education, patience, and practice? Better thought, right? Okay. With supported decision making, supported decision making is something that can be carried out in all aspects of life, of the person's life. I had mentioned this earlier. We all seek help with difficult decisions, and we're encouraged to do that. People with disabilities deserve the same. So we're going to talk about application of supported decision making along with other alternatives in the areas of finance, education, and healthcare. So when we're talking about supported decision making in healthcare, support is often required to understand the information that the consumer is getting, the person is getting, to communicate with providers or manage daily health needs. These are just some examples. With supporters, they can help access health information, help you understand medical information, and help you make medical decisions. Other alternatives for healthcare is a power of attorney. Power of attorney for healthcare in California is also known as the medical power of attorney. It's a legal document that gives the person where a person gives up a right and gives it to another person. And it's usually, in California, it's usually part of the Advanced Healthcare Directive, which I'm going to talk about. Powers of attorney can be general over everything, most things, limited, maybe only for education purposes or health purposes only. And it could be durable, meaning it's effective on the day it's signed and either notarized or witnessed, or springing. It's going to come into effect down the line. So a healthcare directive is that type of springing power of attorney. But for a power of attorney to work, the person who's giving up that right has to have capacity to understand the effect, the benefits, and the risk of signing the power of attorney. The person doesn't have to understand all the legal language and the big words in that document, but needs to understand that by signing this, I'm giving my mom the right to take over my finances. And that's a good thing because I have a hard time dealing with my finances. But it means I can't make any decisions about it. My mom is going to make those decisions. But I do know, and I should know, that I can take that power away from my mom at any time. And I can assign that power to someone else, or I can just decide, hey, you know what? I'm not going to give anyone a power of attorney over my finances. I think I can do this. So I have capacity. I can, let's say that I'm gonna, I'm in the middle of a real estate transaction and I have to go somewhere where there's not going to be, I have to go out of the country for an emergency where, and there's not going to be any Wi-Fi or any way for me to communicate. I can sign a power of attorney giving my mom the right to deal with that real estate matter only. So when that matter ends, so does the power of attorney. So that would be a limited durable power of attorney. So so for example, someone with a disability, if that person has the capacity, as I've explained, that person can sign a power of attorney assigning someone else, for whatever the matter is, uh, healthcare, whatever, education, finances. So that's another way to do it, is having a power of attorney. Or I can have a circle of support too. The other way to do it is a HIPAA form. So let's say my mom calls my doctor and wants medical information about me. Rightly so, the doctor's office is going to say, Mom, we can't release any information to you about Maria. She's going to need to sign a HIPAA form so that we can release that information. And my mom would say, okay, send me that form. And then we would sit to get down together and she would explain the form to me. And either I'll sign it or not sign it, right? But if I sign it, then the HIPAA form would allow my mom to get that information and even participate in my healthcare. So that's another way. That's an alternative. These are all alternatives. So the Advanced Healthcare Directive is usually thought of like, for example, it's the kind of thing that's like, it could be springy, meaning it'll come into effect when I've lost capacity, or here in California, you can make it active immediately upon signing. I'm going to show you the second link. So the way we all know healthcare directives is, let's say I have capacity and I signed an advanced healthcare directive saying that if I ever lost capacity, then, my mom could make healthcare decisions for me. So I'm involved in an auto accident, I'm in a coma, I have this advanced healthcare directive. My mom is going to be able to make healthcare decisions about me. The doctors may say, hey, you know what? We we need to decide whether we need to pull the plug or not. And my mom is going to, and in my healthcare directive, I may have said, I don't want to be on artificial life support. And so my mom will know that it's time to pull the plug. That's how we typically think about a healthcare directive. But I want to show you this one that I found that I thought it was interesting. This one it's easy to do. And this is a form from the California Advanced Healthcare Directive. And it says, I want this person to make medical decisions if I can't make my own. If the person cannot do it, then I want this person to make medical decisions, and then put an X next to the sentence you agree with. My medical decision maker can make decisions for me right after I sign this form, or my medical decision maker will make decisions for me only after I cannot make my own decisions. Then it says here, how do you want your medical decision maker to follow your healthcare wishes? Total flexibility, some flexibility. And here, if there's some flexibility, this is where I would talk about what that flexibility would be, or no flexibility. So this is one where you can either, the person who fills this out and signs it either makes it effective right now, or it becomes like a springing power of attorney when that person can no longer has capacity. I thought I'd show you that. So let's go back to presentation. There we go. Okay, supported decision in finances. Support is often required to understand financial information. I can tell you, I need that kind of support. Communicate with banks or manage money. So why can't, if we can do it, typical people, why can't people with disabilities have that same option through supported decision making? But there are other ways to deal with finances. So one way is to set up automatic bill pays from my account. So it's easy, I don't have to worry about that. I can also have a joint bank account with my mom. So she would have access to the account, help me manage the account. Um, uh, the regional center has, when someone turns 18, they become eligible for what's called supported living services, which includes teaching the consumer how to access the community, transportation, clean the house, cook, manage money. If the only thing I have in life is the benefit I get from Social Security, and my mom is my representative payee, why do we need anything else? Don't need a limited power of attorney for that. Don't need a power, I'm sorry, we don't need a limited conservatorship or power of attorney. Nothing. Because in fact, my mom, every year, the Social Security Administration is going to ask for an accounting on what she spent the money on me, like what, how much money is left, etc. For finances, you can also do a power of attorney. So there are all these things that you can do, mix and match. You can also set up a special needs trust and a trustee would manage the special needs trust. You can also set up an ABLE account. Here in California, it's called a CalABLE account. And I can actually, if I'm the person who has opened the account, I can assign my mom to be my authorized legal representative. And she's the only one who's going to have access to my ABLE account. She'll be managing my ABLE account. Although I am the owner of the ABLE account, she will manage it. So when you designate an authorized legal representative, that person is the only person who can manage the account. If you want more information on CalABLE, we're going to put the website to the CalABLE program so that you can learn more about it. I also do a training on the ABLE program. This supported decision making in education. So fact is that many children with disabilities are not given any ability to make choices in the area of education, no chance to learn from mistakes, or maybe make choices in other areas too. And as I mentioned before, schools commonly promote conservatorship as the only option when we've seen that it's not necessarily the only option. And it's good to practice this. It's good that the student practices decision making from the earliest age possible with help, supported decision making. These are ideas to practice supported decision making from an early age. Have the child attend and participate in IEP meetings in early grades as much as possible. IEP goals should be ambitious, promote student involvement, target self-determination, self-advocacy, and problem solving. It's really very easy to continue making educational decisions for your child once your child turns 18, because the California Education Code allows the students. So let's say that I'm 18. I'm going to download there's a form from the court that you can use, or we have a form in our Special Education Rights and Responsibilities Manual in Appendix P. That's the second link. And I could sign it and assign my mom the right to make educational decisions for me once I turn 18. That's it. I don't need limited power of attorney for that. I don't need, I'm sorry, limited conservatorship or power of attorney. I don't need any of that. It's as easy as filling out and signing the form. Other alternatives to educational decision-making, of course, power of attorney, limited conservatorship. But why do it when all you need is that form? Okay, so we've come to the end of the presentation. I'm also going to provide you with resources on the different topics that you'll want to look at. And we're going to go ahead and take questions and turn off the recording.
Definitely about to turn off the recording. I do want to address a couple things in before we take questions. Is that okay if I have 2 minutes? Perfect. I want to thank people for joining. I know that we have some individuals that joined later. Jessica, I just read your chat you sent to me. We will be distributing a copy of these resources as well as a link to the video of the recording. We just need 80% of people to fill out the survey. So I am going to take this opportunity to drop the survey link in the chat. I also just want to apologize for the issues that occurred with the closed captioning. I am sorry that I didn't catch that sooner, everybody. I once again will be providing a copy of resources and a copy of this video in after I receive 80% of those lovely survey results. And I do need just 2 more minutes because I want to show a couple of slides about survey, if you don't mind.
Sure, I'm going to stop sharing.
Thank you, I appreciate that. In the chat, there is a link to the survey, so if that is easier for you, feel free to do so and click on it. I also am going to take a moment to pull up on screen and talk about our upcoming conference. It's called the Information and Resource Conference, the IRC. It is a completely free conference that we are hosting with support for families in partnership with San Francisco Unified School District and the CAC. We offer free interpretation for all workshops. We also have workshops led in Cantonese and in Spanish. Feel free to scan this QR code or log into this website. I will be putting it in the chat after I stop sharing the slides. And we want to make sure that you are able to attend this free conference at John O'Connell High School in San Francisco. Once again, feel free to scan the QR code or click on the link that will pop up in the chat to register. A friendly reminder that our interpretation service requests are due by March 12th. So that's just around the corner. Taking a moment to present it in as well on the slide. And in case the link doesn't work for you in the chat, I just want to say thank you so much to DRC. We will provide time for questions and Q&A, but I also wanted to provide a QR code for the survey if for some reason the link in the chat is not working for you. I'm going to provide one more reminder. We're looking for that magic number, 80% of surveys filled out in order to get the resources sent to you directly and a copy of the recording emailed to you. All right, I'm going to take one more moment to leave this on screen just in case, and then I'll pass it back. And I also want to thank you so much. This presentation was very informative. I was very excited to attend on a personal level and a professional level, and I'm leaving. I clicked on resources too. So thank you so much. I'm going to go ahead and stop sharing screen and pass it back to you.
Okay, so Raymond or Lonnie, do you guys want to see if there are any questions in chat, or you can also raise your hand if you want.
I don't see any questions in the chat. All I saw was the people asking about interpretation. Oh, the recording's still on. Maybe we could stop that, please.
The recording's still on?
Yeah, it's still showing it's on.
Let me try one more time.